What if the outcome of your lawsuit changed just because you filed in federal court instead of state court? That sounds unfair, right? But for decades, that's exactly how the system worked. This case, Erie Railroad versus Tompkins, completely changed that and reshaped American law. Let's meet the parties. Tompkins was a Pennsylvania man walking along a railroad path at night. The defendant, Erie Railroad, a company incorporated in New York. That difference in citizenship would become the key to everything. One night, Tompkins was walking along a commonly used path next to the tracks. A passing train struck him. He claimed it was a door sticking out, and he was badly injured. Tompkins sued, saying the railroad was negligent. But Erie had a very different story. Here's the twist: under Pennsylvania law, Tompkins might be considered a trespasser. So the big question became, should a federal court apply state law, or its own, general, law? At the time, federal courts often ignored state common law and used their own version of general law. That came from an old case called Swift versus Tyson, which allowed federal courts to think independently. But Justice Brandeis said, this system was flawed and even unconstitutional. The Supreme Court ruled, federal courts must apply state substantive law in diversity cases. There is no such thing as a general federal common law for these cases. If it's about rights and duties, federal courts must follow the state's law. This decision stopped people from forum shopping, choosing courts just to get better outcomes. It also reinforced federalism, making sure states control their own laws and legal standards. Here's the bottom line: after Erie, federal courts can't make up their own rules in diversity cases. They must apply the same law a state court would use. And that simple idea still shapes how lawsuits are decided today.